Welcome to the class. We are going to begin with a new video series on doctrines in company law. Okay, so this is the first video in the series, and in this video, let's learn about doctrine of lifting of corporate veil. Okay, so first let's understand what is this doctrine all about, and then we will learn details about it. Okay, let's see. Yeah, so the first question arises that what is this doctrine all about? Okay, we all know as per the company law, a company is an artificial legal person, isn't it? Yeah, that means once registered, it gets a separate personality or a separate entity which is different from its members. So just before registration, it was all members, and once it is registered, it becomes a different entity, totally different from its members. And therefore, in effect, a corporate veil is created. That means on the members veil, we can say a corporate veil, or rather on the member's face, a veil is put. What is this veil all about? The veil is corporate entity. That means the company's corporate entity acts as a veil on the face of the members. In a way, we can say that once registered, members will not be identified, only company will be identified. That is the same thing what a face veil or a face cover does, isn't it? We will see only the cover, we will not identify the face. Same thing is happening here. Members are not identified. In fact, they are identified as the corporate personality. Okay, so this doctrine comes from this concept. As we have seen in previous videos, you might have seen in Salomon versus Salomon and all, the court said that once registered, it is a separate entity and it is not our business to look behind and identify the members. But in the long run, what happened? This particular corporate veil or the face cover had been used or rather misused by many members. Say for example, they will create a company and do things which they cannot otherwise do. See, if a member does, he'll be identified and he'll be made liable. Such things, he'll make a company and in the name of the company, he'll do that so that he can escape the liability. So this corporate identity of the company had been largely misused. Okay, at this point, the purpose of this doctrine or the need for such a doctrine has developed. So this doctrine actually wants to tell us that in case of emergency or in case if the situation demands, you can lift that wheel. You can lift that wheel. Why are we lifting the wheel? So that we can identify the parties behind it and make them liable and accountable. That is required for the reason that this corporate identity actually had been envisaged for a very good purpose and we should not allow anyone to misuse it. Okay, so the purpose of this doctrine of lifting of corporate veil is to allow people, court or anybody when the situation demands to lift the corporate veil so that the members or the directors behind the company can be identified, made accountable and made liable too. Okay, so now there are certain situations which are recognized under this doctrine when we can actually lift the corporate veil and identify the parties. So let's see what are they. Yeah, so there are two cases. One is under statutory provisions. That means over a period of time, statutes incorporated these provisions whereby enabling us to identify parties behind the company. So let's first see the statutory provisions. When the number of members goes below minimum. We all know in a private company, minimum 2 members, in a public company, minimum 7 members are required. And at any point of time, if that goes down we should smell the rat. Okay. Then at any point of time, a huge or serious misrepresentation happens or misrepresentation is done by the company, we should think that it is the people who behind the company is actually doing it, and we should identify them. Next is failure to deliver share certificate beyond a particular period of time should definitely raise our doubts, and we should be able to make people behind the company liable. Now, misdescription of name. At any point of time in any document, if a person, a director or a whole-time director or a manager or a company secretary signs on behalf of the company where the name is not written properly, that means the person who is signing will be made personally liable. In case of holding company must inform its members about its stake in its subsidiary companies. In case if it is not done, that is a serious problem and the directors can be made liable for that. Any fraud happening in the company, we should identify the directors, okay, and make them liable. Ultra-vires act, any ultra-vires act. Ultra-vires means beyond the power. Whenever the company does something beyond the object clause of the company, that means it is the director who is doing and we should make them liable. At the time of conversion of a one-person company into a private company or a private company into a public company or a public company into a private company, whenever such conversion takes place, we should identify people behind the company. Then under any other statute like Companies Act or Securities and Exchange Board of India Act or any other legislation, if there is a liability, that liability should be for the directors, and for that purpose also we should identify the directors behind the company. Okay, so these all are statutory provisions made in the Companies Act, whereby it is the director who will be identified, not the company or company's corporate personality. Okay, now there are another set of situations which are laid down by judicial interpretations. Means in each case the court said that this is a particular case where we can lift the corporate veil, or this is another situation where we can lift the corporate veil. Okay, so let's see those situations. Protection of revenue. Sometimes company is formed only for the protection of revenue so that individuals do not want to pay the income tax. Definitely that is a wrong practice and the party will be identified. If the company gets an enemy character, that means the company is funding terrorism, the company is funding war. In such cases, it is the director or the people who behind the company will be identified and made responsible for. Any economic offense, it is the director who must be held liable for it. If the company is formed in order to avoid some welfare measures which are compulsory, naturally people behind the company will be identified. And if the company does any contempt of court is something which only human beings can be done. So therefore, we will identify the party behind the company and make him liable also. And for the purpose of prevention of fraud, that means there is a doubt that fraud is going to happen, and before the fraud actually takes place, we can identify the person so that we can prevent the fraud happening. Okay, so in these circumstances, in each of the case, court through different judgments laid down the rule that these are situations where it is the party behind the company who will be identified, not the corporate personality of the company. Okay, so is that clear? Doctrine of lifting of corporate veil simply says that even though we accept there is a separate personality, there is no need of identifying people behind the company in normal circumstances. But in these circumstances, first set of statutory provisions, second set of judicial interpretation, we must identify parties behind the company, whether it is director or a manager or a member, we must identify the parties to make them accountable. This is doctrine of lifting of corporate veil. Okay, and do put your opinions, suggestions, doubts in the comment box. I'll be happy to help. Thank you.